Hi, and welcome to Chapter 3, Dispute Resolution. The process of litigation may influence the outcome of a dispute as strongly as substantive law. That is all the more reason to use preventive law and stay out of court. Facts are ventriloquist dummies. Sitting on a wise man's knee, they may be made to utter words of wisdom. Elsewhere, they say nothing, or talk nonsense, or indulge in sheer diabolism. Some say there is only one good kind of legal dispute, the one that is prevented. You have a chance to go broke twice in your life, once when you lose a lawsuit, the other time when you win. Litigation versus alternative dispute resolution. Litigation refers to lawsuits, the process of filing claims in court and ultimately going to trial. Alternative dispute resolution is any other formal or informal process for settling disputes without going to trial. Disputes between parties may be settled through negotiation. Parties make offers and counteroffers either face-to-face or through lawyers. Mediation is a non-binding procedure utilizing the services of a neutral third party to assist negotiations and recommend a resolution of the parties' dispute. Mediation is non-adversarial and tends to reduce antagonism. One of the advantages to mediation is that there are few procedural rules, which allows the mediator to tailor the mediation to the parties' needs. Also, because the disputes end only if the parties can reach an agreement, mediation reduces or eliminates the bitterness and hard feelings that often linger after a trial. Finally, the parties get to choose their mediator. Some of the disadvantages are that the parties must pay the mediator's fee. Also, without the threat of an adverse ruling or verdict, parties may be less willing to make concessions or otherwise make a good faith effort to resolve the dispute. Arbitration refers to dispute resolution utilizing either a neutral third party or a panel of 3 people chosen by the court or agreed to by the parties, or both. Arbitration can be either binding, in which case the arbitrator's decision is legally binding, or non-binding, in which case the arbitrator's decision is merely advisory. It's increasingly common for parties to include in their contracts an agreement to arbitrate any dispute arising out of the contracts. A submission is a written referral to arbitration which identifies the parties, the nature of the dispute, the amount in controversy, and the location of the arbitration, and expresses the parties' intent to be bound by the arbitrator's award. Most states require that a matter be referred to arbitration within 6 months of when the dispute arises. The parties may ask the arbitrator to resolve disputed questions of fact, law, or both. In a hearing, the parties present the evidence, including, but not limited to, the testimony of witnesses and arguments in support of their respective positions to the arbitrator. Evidentiary and procedural rules tend to be less formal in arbitration than in court. An award is given at the conclusion of the hearing, or sometime thereafter, generally within 30 days. The arbitrator issues a written resolution of all disputed issues. The award may be accompanied by a written opinion outlining the arbitrator's factual and/or legal conclusions in support of the award. Many contracts include an arbitration clause, which provides that any dispute arising from the contract will be submitted first or finally to arbitration rather than to a court. If the parties agreed before their dispute arose to submit some or all of their disputes to arbitration, the parties seeking arbitration of a particular dispute may ask a court to compel the other party to submit to arbitration. Arbitrability means that despite the fact that a contract contains an arbitration clause, a party to the contract may claim that he is not bound by the arbitration clause, in which case a court will be asked to decide whether the clause is enforceable, and if so, whether the issue is covered by the clause. A mini-trial is a short-form trial presented to a judge whose decision is not legally binding but may assist the parties in evaluating their claims or defenses. A summary jury trial is similar except that the case is presented to a mock jury so that both sides can see how a jury might decide to vote if the case actually went to court.